All right, today's date is February 17th, and this morning's panel, as you can see, is Judge Carr, Judge Sutton, and myself, Judge Teodosio, who will be presiding. And the first case that we have set for oral argument is case number 21CA0051-M, Vogel versus Northeast Ohio Media Group, dbacleveland.com. First of all, we want to thank you for appearing today by Zoom. That's very kind of you. And each of you will have 15 minutes, of course, to present your arguments. Now, the appellant may reserve up to 5 minutes. When you get started, Attorney Owens, just let me know if you do want to reserve time, and I'll keep track of that for you and let you know as you get close. I don't think it applies in this case, but just since we are being recorded and on the YouTube channel, I always like to remind the parties and the public, whoever's watching, of our rule that we do not use victims' names or children's names during the presentation of the arguments. Again, I don't think that applies to you, so we'll move on and let you know that we've read the briefs in this matter and we are prepared to proceed if you are. So, Attorney Owens, would you like to reserve some time?
Yes, I would like to reserve 2 minutes for rebuttal, please.
2 minutes?
Yes, please.
All right, and I will let you know when you get close. Let me get my clock set up here. And I'm ready when you are.
Thank you very much. May it please the court, I am Mark Owens and I am representing Stephen Vogel, former esteemed chief building official for the city of Medina. This appeal tests the integrity of Civil Rule 56 as it was applied by the trial court, which the evidence shows erred as a matter of law in ignoring a plethora of genuine issues of material fact and standing on what we demonstrated to be a sham investigation into unsubstantiated allegations made by 2 female employees, Ms. Morris and Ms. Haley, who colluded, we believe the evidence shows, or at least creates genuine issue of material fact, colluded together with the mayor's administrative assistant, Don Conwell, to bring these allegations and bring Mr. Vogel down without giving him an adequate opportunity to defend himself against these allegations. The evidence established that the city failed to interview or request statements of any witnesses who could contradict what Ms. Morris and Ms. Haley said regarding Mr. Vogel. And just to give you some examples, Inspector Tom Verostek observed that the 2 women had a positive relationship with Mr. Vogel, and he perceived no tension whatsoever among them in their working environment. He was not interviewed, not asked to provide a statement. Justin Benko, property maintenance inspector, who also worked as a direct report to Mr. Vogel, testified that he never witnessed any inappropriate behavior and he never heard any inappropriate comments made by Mr. Vogel in his interactions with the 2 women. Nor did Ms. Morris ever express any fear in being in the same building with Mr. Vogel. Mr. Benko, again, also was not interviewed or asked to provide any statement. Christy Chrysler often socialized with Ms. Morris outside of work. They spoke on the phone regularly. They went to church together. She testified that she had no idea about these allegations until she read it in the newspaper. Ms. Morris never said anything to her in all their interactions. And she was also not asked by Mr. Huber to provide a statement, and she was not interviewed as part of this investigation. Nicole Musgrave, associate planner, also had Mr. Gregory Hannon as her boss. She testified she never saw any of these alleged incidents, never heard any of the alleged comments. She was also not interviewed. Elaine Klavesniewski testified that Ms. Moore's relationship with Mr. Vogel appeared very professional and that there were only some joking or silliness here and there, none of it of a sexual nature, and none of it was taken seriously by anyone. She was also not interviewed. Mr. Vogel had given Mr. Huber names of people that he felt could be good character witnesses for him, including the fire marshal and other female employees that he worked with. Mr. Huber didn't speak with any of those folks as well or take their statements. In addition to that, the evidence shows that similarly situated female employees, including Ms. Morris and Ms. Haley, engaged in flirtatious and inappropriate conduct at work, including toward Mr. Vogel, without any consequences or discipline.
Counsel, before you get into that, when you were going through all the witnesses that did not testify or testified that they hadn't heard anything, and that you didn't feel that you're alleging that the investigation by the city was not thorough enough or incomplete or whatever you want to call it. You know, when I'm listening to it, I would say it sounds kind of like just a plain old wrongful discharge case. What would be your response to that?
Well, here
instead of a discrimination case is what I'm trying to say. Mm-hmm.
Well, we believe it is a reverse discrimination case because here we do have background circumstances that support the inference that the city was in fact one of the unusual employers that discriminated against male employees, not only with how the investigation was conducted, that's one of the background circumstances. And if you look at the 3 Sixth Circuit factors, we presented facts to create genuine issues as to each of those 3 factors. First, Ms. Morris, Ms. Haley, and Mr. Vogel share the same ultimate decision-making supervisor, Mr. Gregory Hannon, and ultimately even above him, Mayor Hanwell, for which they all work directly or indirectly. They were all subject to the same standards and procedures for workplace conduct and for sexual harassment, but only Mr. Vogel was placed on administrative leave and purportedly investigated and lost his job. And the evidence showed that Ms. Morris in particular engaged in the same conduct without any differentiating or mitigating circumstances that would distinguish her conduct from the city's treatment or the city's treatment for that conduct. And what I mean by that is the record shows that Ms. Morris routinely called Mr. Vogel Baby Steve, sent him little cute smiley face emojis, talked about her personal life with him, complained to him about contractors that would come in and hit on her. And she just in general engaged in a regular inappropriate office joking and banter in the office with Mr. Vogel.
But he never counsel, he never made a complaint that this was offensive to him, that this, as you call it, inappropriate conduct on her behalf was offensive to him.
Right. He did not make a formal complaint as to that. And what we provided in our brief was authority to indicate that he doesn't have to complain in order to be a victim of sexual harassment. What is important is that the city knew or should have known that this was happening and did nothing about it. But no, he did not make a complaint to the city about this. As a matter of fact, he didn't even know that anything was wrong. That's one of the points that we make in our brief. No one even told him that there were any issues with the 2 women. He was not given any chance to, if there was something that was offensive to them, he was given no chance to address it. He was just blindsided by these complaints that were only written at the urging of Ms. Conwell, who indicated to Mr. Huber that she overheard them talking and she spurred them on to file complaints against Mr. Vogel. They spoke on the weekend before they submitted their complaints. The trial court indicated that they made formal complaints to Human Resources, which is impossible because Mayor Hanwell testified that there was no Human Resources Director and there hadn't been for several years. So there was no formal complaint that they made to Human Resources. It was made to Ms. Conwell and given to Mr. Huber.
Attorney Owens, was Mr. Vogel a supervisor?
He was the head of the building department. He had no authority to hire, fire, or discipline. That was his superior, Gregory Hannon, had that authority. But he testified, and I believe the mayor also testified that Mr. Vogel did not have hiring ability or firing ability, although he did supervise the department in general. Now, Ms. Morris did testify that.
Counsel, I don't mean to be accused of splitting hairs here, but technically the only one that really could hire or fire would be the mayor, right?
Well, correct. Ultimately, he was the ultimate decision maker.
Okay.
Which they all shared.
Okay. And so Mr. Vogel, as well as Mr. Hannon, could probably recommend discipline about individuals?
They could make recommendations, correct.
Okay. All right. Just so we were all on the same page.
He never, although Mr. Vogel, the testimony establishes that he never threatened any adverse employment action toward Ms. Morris or Ms. Haley. They testified that they were never threatened with any kind of adverse action. He never tried to use his position in any way to take advantage of them. That was clear from the testimony.
Did they report to Mr. Vogel or?
There was a reporting relationship that they had with him, although, as I indicated, Mr. Hannon was ultimately in charge of the department, but Mr. Vogel was at a level in between Ms. Morris, Ms. Haley, and Gregory Hannon.
Did he review them?
He did give them reviews. As a matter of fact, he always gave Ms. Morris a positive review. The last review he had given her was an 8 out of 10, which upset her. She thought she should have been a 10 out of 10 and expressed her displeasure to him. Another point I'd like to make is Ms. Morris insisted that she could not work with Mr. Vogel anywhere in the building. One of the options that were presented to her was she was asked whether she would be comfortable with Mr. Vogel being transferred to the basement area, have his office down there. She said, no, absolutely not. But nevertheless, she went with him on 2 inspections. The second of which was within months of his termination, and her allegations alone, rode along with him in his car, never expressed any discomfort with that. And there were no issues. So if actions speak louder than words, I mean, certainly there are so many facts and circumstances here that create genuine issues of material fact that we believe the trial court should have allowed this case to proceed to be heard on the merits at trial. There was also allegation made by, well, the defendants that Mr. Vogel didn't dispute the allegations. That is untrue. Mr. Vogel did, in a detailed email to Mr. Huber, point by point dispute all the allegations that were made by him. So I want to make that clear for the record. He stated to Mr. Huber in email correspondence that he would do everything he could to fight these allegations, so that they were absolutely untrue.
Is that email in the record?
It should be. Yes, Your Honor, that should be part of the record.
Okay.
Well, was it submitted? I guess, I think what Judge Titosi is actually asking, again, not to be splitting hairs, but was it submitted on summary judgment?
That's a good question.
Thank you, Judge Carr, for clearing that up.
I can't confirm that as I sit here right now. I believe that was, or at least it was a deposition exhibit.
Okay. Well, and of course we'll look at the record anyway, but.
Okay.
You're at 11 minutes, 30 seconds right now, just to let you know where your time is out of the 15.
Okay, so I have a couple more minutes before I get into rebuttal time.
Yes.
Thank you. Ms. Haley testified that the only comments that were made to her that she felt were inappropriate were comments regarding her earrings matching her shirt, or that Mr. Vogel liked her shoes. And she testified that she would not have any concerns if a female coworker made those comments. That just goes to show you how innocuous these comments were, that all of a sudden now are becoming the basis for written complaints against Mr. Vogel. 2 other people that were not interviewed that should have been, or statements taken. Service Director Nino Piccoli testified that it was Don Conwell who was upset, not Applees, Haley, and Morris. Ms. Conwell was upset and urged them to make these complaints. Mr. Huber did not interview Mr. Piccoli as part of his investigation. He didn't interview Ms. Conwell as part of his investigation either, even though she testified that she overheard conversations between the 2 women regarding Mr. Vogel. The only outside documentation that Mr. Huber collected as part of his investigation were the emails that Tammy Morris gave him. He testified very clearly he didn't seek out any emails from other employees. He didn't review Mr. Vogel's phone to try to find emails or text messages between himself and between Mr. Vogel and the 2 women.
Counsel, you are now at your rebuttal time, so you may
Okay.
continue, but I just want to let you know.
That's okay. I will reserve the remaining time for rebuttal.
All right, you'll have 2 minutes for your rebuttal then.
Thank you.
Attorney Beck, are you prepared to proceed?
I am, Your Honor.
All right, whenever you're ready.
May it please the court, Mr. Owens. Your Honors, on behalf of the city of Medina and Ms. Morris and Ms. Haley, we obviously have a very different impression about what happened in this case that has been on a very long path. I mean, this is the third lawsuit filed as a result of this. And part of this case has already been dismissed that was affirmed by this court. And really the two issues that were, or the three issues that we're looking at is, was there reverse discrimination? Was there a hostile work environment? And was he subjected to intentional infliction of emotional distress as a result of these underlying facts? And really this case as it sits right now is a classic situation where the facts simply don't support these allegations in any way. In other words, it is a very difficult process to prove reverse discrimination. And Mr. Vogel has testified in his deposition. When I asked him directly, and it's on page 202 of his deposition, I asked him, well, what facts do you have to support this allegation that you were discriminated against based on your gender? And his answer was, I don't have anything to support it. Now, this happened in the middle of discovery. And after that point, they had opportunities to conduct an investigation to determine whether there was some process within the city of Medina that was discriminatory toward the majority, that they had treated men much differently. There is no evidence. I asked Mr. Vogel in his deposition, are you aware of any situation where someone had complained about discrimination and there was no investigation conducted? Are you aware of any situation in where women were treated differently than men? And he had none of that information. And of course, none of it exists in the record either. So we have to step back and say, well, what did the city do wrong? The city did exactly what the United States Supreme Court has dictated, which is take prompt remedial action and eradicate discrimination from the workplace. What happened in this case was these two women who had been subjected to Mr. Vogel's continuous and repeated conduct, which made them feel uncomfortable, finally decided to report it. And this is the classic nature of hostile work environment. There is no one individual event that if you singled it out and said, this in fact is like a quid pro quo, but the cumulative nature of this, the hostile work environment was created. Ms. Morris was very clear in her deposition that Mr. Vogel had anger issues. He would become angry when he would ask her out, or he would do things like that and she would rebuff him. He would be mean to her and so forth. And if you look at Mr. Huber's 11-page single-spaced report, what is replete through the entire report is every witness testified almost to the person that Mr. Vogel had anger problems, anger issues. And so this was all part of this process. So what did the city do? It immediately conducted an investigation. The law director, who is an experienced litigator, met with these two women, obtained written statements from these two women. Mr. Vogel was placed on paid administrative leave because that's what you do that's your initial remedial action. He was given these written statements. He was given an opportunity to rebut them. He met with Mr. Huber. Mr. Huber identified and interviewed many, many witnesses. He did interview Mr. Benko, contrary to what was said. But the point is, Mr. Huber conducted the investigation that he thought was sufficient. And then he reported that to the mayor. The mayor then conducted a pre-disciplinary hearing, giving Mr. Vogel again an opportunity to present his case. And the mayor then made the decision for termination. And this is somewhat textbook about how this is supposed to be handled.
Counsel, before you go further, I want to get a better understanding of the investigation and the pre-disciplinary hearing, if you don't care.
Sure.
With the investigation, did Mr. Vogel, in fact, send an email to the mayor denying everything and suggesting particular witnesses?
I don't recall that specific email, Your Honor, to be honest, but I know that Mr. Vogel did deny the allegations. He definitely did that.
Okay. Because it did sound in your brief like you said he didn't deny them.
Well, no, I mean, part of the analysis in the Huber report is that on the whole, he denied he couldn't remember things where he denied ever asking these people out. He denied that he asked her out for Valentine's Day. He denied that he suggested to give her massages and all of these things. And of course, in the report, Mr. Huber notes that there were witnesses contemporaneous with the events that recall Ms. Morris complaining about that. And there were people that, and so it is the nature of this conduct that makes it so difficult and pervasive. And it was affecting, Ms. Morris in particular, her ability to work. So that is why.
Well, let me ask you this: were there witnesses that Mr. Vogel suggested that were not interviewed by your law director?
I do not remember. I don't know that, Your Honor. I'll accept for purposes of this discussion that Mr. Vogel may have mentioned people, but Mr. Huber, in his detailed report, interviewed at least 6 or 7 people and discussed those issues, with him, and gave Mr. Vogel, and also interviewed Mr. Vogel in detail, and then talked to him. So from our perspective, there is no evidence in the record of any gender-based discrimination.
Okay, and I have one more question, I think, in regard to the predisciplinary hearing. Was Mr. Vogel given an opportunity to present any witnesses?
He was advised of at that hearing before the mayor, that meeting with the mayor, and he came along. He is, in fact, a supervisor. He claimed he was trained not only on the employee manual, but also on harassment training. So he's a person that is supposed to be knowledgeable of this thing. And I will make a comment with respect to the hostile work environment. It is somewhat inconsistent for a supervisor supposedly trained in discrimination law to claim that they were subjected somehow to a hostile work environment by subordinates and never give any corrective action, never to advise those people not to do that, never to report those people to Mr. Hannon. I mean, the fact is that there is absolutely no evidence whatsoever that Mr. Vogel found any of the conduct that he's claiming to be hostile unwelcome. And that is the linchpin on all of this. It has to be, not only does it have to occur, it has to be unwelcome. These women say all of his conduct was unwelcome. Mr. Vogel never said that. And in fact, in his capacity as their supervisor, he had an obligation to take action if he saw them doing things that were inappropriate.
Counsel, let me just, this doesn't necessarily make or break the case, but I'd like to get a better understanding. And it may apply maybe in regard to allegations with intentional infliction of emotional distress. So what was his actual status? Was he unclassified, classified?
He was unclassified.
He was unclassified. So
he was unclassified, employee at will.
So he really didn't need to have a predisciplinary hearing. That's why you keep talking about it as a conference. Is that what you're saying? That's right, Your Honor. According to the employee handbook, that was sort of the process that you would file in these situations. This would have been categorized as a certain level of an offense. But before any disciplinary action was to be taken by this type of employee or any, they would have a conference with the mayor and it would have an opportunity to explain themselves. And what Mr. Vogel did in that situation, he apologized and so forth. But the truth is that in this type of situation, the investigator has to make a decision, and it has to be a credibility decision. That old mantra of, we can't decide because it's a he said, she said, that ship sailed more than a decade ago. Attorney Huber was the one that had to make that call. And based on everything that he heard, all the information that he saw, he made the determination that it was more likely than not that these allegations that these women espoused were true. And implicit in that, of course, is the decision that Mr. Vogel was not telling the truth. I mean, a lot of times, as this court knows very well, in these investigations, if the person who is being accused is candid and open and truthful about these allegations, many times there's a lot that can be done that can salvage their position and a lot of training and all sorts of things. But the minute you start denying that they occur and the fact finder finds that they did occur, now you have a sort of a double-edged sword, because now you've not only not been truthful, but you engaged in conduct which could warrant discipline. So from our perspective, there is no evidence of any type of reverse discrimination. I mean, there's just nothing in the record to support that these employees were not similarly situated. If we look at the analysis from disparate impact law, I mean, there have to be in a situation where they
are similarly rooted. They're not. He was their supervisor. He had direct control over them. He directed everything they did during the course of the day. He gave the evaluations. They're not similarly situated at all. And so to compare them to him is completely, it misses the mark completely. With respect to the hostile work environment, again, if we look to Mr. Vogel's deposition, he doesn't even have a concept of what that is. I asked him point blank on page 211 of his deposition, what is your evidence? What is your finding of or belief of a hostile work environment? He didn't mention the women. He said that it's the pressure from management. He thought the hostile work environment meant that if I feel pressure from management somehow, and I feel it's aggressive, and in that situation, what it dealt with is that he was short-staffed and felt that he was getting pressure from his supervisor that he wasn't working hard enough or something, that somehow created a hostile work environment. That's his sworn testimony of the hostile work environment, not this notion that these women somehow made him feel uncomfortable and that their activities were unwelcome. So there's no evidence of any hostile work environment. And actually the notion that someone could make a complaint about sexual harassment in the workplace and then be subject to a counterclaim or an argument that you've created a hostile work environment against me, imagine the chilling effect that would have. I mean, this case is classic in that situation. Same with the claim on intentional infliction of emotional distress. I mean, that is a very, very narrow allegation. This court and every lawyer that litigates sees this type of claim being thrown in almost every complaint involving tort and employment law, but very, very rarely are they viable. And this is not an outrageous situation that it confronts all decency. I mean, this is simply a situation where an investigation occurred. It occurred promptly. They took immediate remedial action. Mr. Vogel simply doesn't like the outcome, and I understand that. But that doesn't create a situation of an intentional infliction of emotional stress. There was no malice here. There was no animus against him. And again, if you look at Attorney Huber's report, I mean, he clearly tries to make it clear that while these are difficult decisions, they seem to be true. And so then he had to make the hard call to say that Mr. Vogel was not being truthful and that these activities that were alleged against him actually occurred. And if the obligation of the employer is to eradicate discrimination from the workplace, the employer has no option at that point. Now, you can challenge whether he should have been disciplined or transferred to another unit, but the fact is that the mayor had the opportunity, had the right to terminate him. And that's exactly what happened. And it was based upon an investigation that was authorized by law and properly conducted. So with that, I will close my argument unless there are any other questions.
Any other questions, Judge Carr?
No,
Judge
thank
Sutton?
you.
All right, thank you, Attorney Beck. Attorney Owens, I believe I said 2 minutes, right? Yes, 2 minutes left for rebuttal.
Thank you. First, with respect to reliance on Mr. Vogel's deposition testimony as to what constitutes a hostile work environment, we provided ample authority in the briefing that is improper and must be excluded. You can't ask a lay witness who is not a trained attorney or even has a law degree questions that are outside the realm of his firsthand knowledge.
Well, counsel, but they can testify as to what was offensive in the work environment.
Right, that is true. But
evidently he didn't say anything about any kind of inappropriate conduct on behalf of these women that was inappropriate when he was asked the question.
Well, and according to Mr. Beck, and I think he's right, Mr. Vogel didn't understand what he was talking about when he said hostile work environment. He didn't understand that concept, which you wouldn't expect a lay person necessarily to know what constitutes a hostile work environment. He also, there was mention of anger issues. This isn't a case about Mr. Vogel having anger issues. None of the complaints, neither complaint involved any anger issues. He was also deprived of access to evidence that may have helped him defend against these allegations. His cell phone was immediately taken. The only cell phone he had at the time was the city-issued iPhone. So he couldn't access his texts, couldn't access the emails that he would have been able to provide to Mr. Huber to show, hey, look, Look at how Ms. Morris spoke with me and interacted with me all the time. This is not true, what's being alleged. There was an implication or a suggestion that maybe Mr. Vogel was not candid. He was very adamant in disagreeing and rejecting the notion that he engaged in any of these actions that the women were alleging against him. He was very clear, it simply did not happen. He did not do these things.
And Mr. Owens, with that, your 2 minutes is up.
Okay, thank you.
Thank you. I want to thank you both for providing us with these arguments. And again, on behalf of Judge Carr and Judge Sutton, we really appreciate you appearing by Zoom for this argument. The court will take the matter under advisement. Of course, we're going to issue a decision in due course, and that decision will be mailed to each of you. As you both know, the opinions are also posted on the Supreme Court of Ohio's website.